Hey, all persons of any level of the justice of the appeals court now sitting in Boston, Florida, within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
And good morning.
Good morning.
Welcome to the January 29th, 2025 sitting of the Massachusetts Appeals Court. Let me introduce our panel. Sitting to my right is Justice Joseph Ditkoff. To my left, Justice Chauncey Wood, and I'm Justice Eric Neyman. Before we begin, let me explain the ground rules. Each side will have 15 minutes to make its presentation. There is no rebuttal in the appeals court. We have read the briefs, we have read the case law, and we are familiar with the procedural background as well. So I would urge both parties to cut to the heart of your argument. However, your 15 minutes is yours to use as you see fit. Ms. Smith, do you prefer Ms. Smith, by the way? Is that okay?
Yeah, that's fine. Thank you.
Wonderful. My understanding is that you will not be able to see the clock from where you are, so every 5 minutes or so, I will let you know how much time you have left, and when you're down to 2 minutes and 1 minute, I will let you know as well. Does that work for you?
Yes, thank you.
Wonderful. Then calling our first case today, docket 24P439, Danforth v. Smith. I would actually ask both parties to remember that this case is partially impounded, so please refrain from using the names of any children or refrain from using any, making any reference rather to any impounded materials. With that said, we'll hear from counsel for the appellant. Mr. Trapp, good to see you.
Good morning, Your Honors, and may it please the Court. My name is Michael Traft. I represent Jonathan Danforth in this case. First, I want to thank the panel for scheduling this case for the consideration of Ms. Smith's situation. Fortunately, I think the wildfires in California have calmed down, and we've weathered a little snow shower this morning, and we're all here. Even after some technical difficulties. So I thank the court for all of its consideration. This case is basically about a modification of child support and how the trial judge is supposed to apply it. You must apply the child support guidelines and compare the current circumstances of the parties and the child with the prior circumstance when the earlier order was entered. And I believe the trial judge ended up being misled by her skepticism of the father's assertion that he didn't have any income. But he was retired, and the analysis has to be based upon not what he said in his prior financial statement at the last hearing 4.5 years before, but what the trial judge in that case determined was his income and was the income of the other party at that time.
Can I stop you? And
sure.
I want to clarify that the finding of $3,800 a week was made in May of 2019.
Correct.
Is that right?
Correct.
And he did not appeal that finding, correct? Okay, so is that the governing finding? Was there any finding after that that is relevant here?
No, because there was never any, there was a temporary order that eventually got vacated, and then the case had been dragged on for several years before we had this trial.
Okay, but he didn't appeal that determination of $3,800 a week.
Right.
Okay.
And he's been paying that,
right.
He'd been paying based upon that determination.
So moving forward to the trial for this modification, the burden is on him, your client, to prove new facts that demonstrate that he is making less than $3,800 a week.
Yes.
Okay. And the judge in January of 2024, in the ruling that we are considering, says, I find your client is lying, if I got that right, and that in fact he's still making $3,800 a week.
Well,
is that right?
The problem is the judge is basing that on a financial statement that he had submitted for a mortgage application in 2017.
Well, what evidence, I guess, to cut to the chase, what evidence do you point us to in the record that the judge's finding is clearly erroneous?
First of all, it is a fundamental change of circumstances that he's on Social Security. He had been on Social Security since 2022. Secondly, he testified about the changes of the circumstances of the relevant assets of the parties. He and his wife had been involved in real estate transfers, and that was the idea of how he was supposedly making this money.
Did the judge credit this testimony?
Did the judge really didn't consider it. She didn't say anything about it other than because he said in the last hearing that he wasn't making any money, and this time he said he wasn't making money, and I don't believe that. Therefore, I find that he's making the same amount of money he was making 6 years ago.
But what is a judge supposed to do when someone comes in and just lies and says, I'm not working anymore, and won't say what their actual income was? Why can't the judge just stick with the old income until someone proves them differently?
Well, how is, I put it on the other side, how is the appellant supposed to prove that things are different? He proved things are different.
He could come in and tell the truth about what his situation is instead of just lying.
Well, what undoubtedly was the truth was that he was making, that he was taking Social Security. What is undoubtedly truth is 6 years later.
So I'm sorry, I'm not quite understanding the relevance, the materiality of him collecting Social Security. I'm no expert on Social Security, but I think he can keep working while collecting Social Security.
He could.
So why is it sounded, I'm not following your argument. My argument seems to be, at its nub, his change of circumstance was he started collecting Social Security, and therefore we have proven he's retired? Is that the argument?
No, because he also testified about the facts of that he's not involved in the change of transfers of real estate. The properties that they owned, he and his wife at the time, have been transferred since that time. His wife is about to retire and reach retirement age as well. Those are all changes of circumstances.
And
now, the judge could say, she can't say he's lying about taking Social Security, but she has to find some fact that justifies saying, since 6 years ago you were making $3,800, today you must be making $3,800, and forever you must be making $3,800.
Where does the burden lie in this complaint for modification? Who has the burden?
Well, he certainly has the burden to show as a change.
Right, and so the evidence of the change, he's got the burden.
Right.
So the evidence, I think you've said, is he's getting Social Security, and he testified that he's not working in the business.
And
the
assets that they owned had changed fundamentally from 6 years ago. The house that had been involved had been sold. That was part of the basis for saying that they were earning this amount of money. There were a number of circumstances he testified. Now, the judge could discredit that, but she has to consider it. Instead of saying what she said right in her findings originally is, well, he said he wasn't making any money last time, and the other judge didn't believe him, so I don't believe him either. So therefore, I believe he's making what he made 6 years ago, and he's forever, for the rest of his life, even after he's retired, he's making that money. Even though he doesn't have the house anymore that they were talking about, that the circumstances, personal circumstances are fundamentally different. All of the financial statements, there were several filed in the course of the litigation in this case, were all there for the court to see, and the change of assets, and he testified about all of that. That's enough to establish that there was a change of circumstances. Now, what the judge has to do is consider the change of circumstances relevant to the determination of the original order from 4 years before. And the judge has to consider the circumstances of the other party. And what was blatant here is we have financial statement after financial statement filed by the mother, which said that she was spending over $4,000 per week, but making no money. Now, she wasn't dwindling assets because her final financial statement had higher assets than she had at the beginning. She always had the same amount of assets.
I was curious, if I could interject, I was curious about this. Broadly speaking, I understand the argument that the mother of the child has assets as well. So, but first of all, is there case law that you cited or can point to that the fact that one parent has a lot of money, if we accept that as true, diminishes, reduces the obligation of the other parent who clearly has a lot of money himself? Why is in essence, why is the fact that she has money and is obviously contributing to the child at all relevant, even relevant to his obligation where he's got plenty of money too?
What's particularly relevant is whether she had income. Now, she says she spends $4,000 a week and has no income other than the child support she's receiving from the father. That's impossible. The money doesn't come from nowhere.
What's the case law that you cite to establish that proposition, that her income is relevant?
That you could ignore the fact that the mother says she's spending $4,000 and only making $600, and remarkably, she doesn't diminish her assets?
Is it an equitable? I'm sorry, but is that an equitable point? Is that what you're saying?
Well, it's the issue of, if you're going to speculate that we don't believe the father, and therefore we think he's making $3,800 a week. But I'm going to ignore the fact that the mother says she spends $4,000 a week and doesn't earn any money, but remarkably doesn't lose any money either. That has to be considered. You have to consider both parties, and if you're going to say the father's lying, you have to realize that the mother has to be lying. It's not possible for what she said in all of her financial statements. So that has to be considered. What it is, how she's magically making this money, or where it comes from, it's from other source that she didn't report. She had over $1.2 million in bank accounts, and she was asked, well, didn't you make any money from that? Oh, maybe it's just in a bank account, and maybe I made $90. But she didn't even report the $90. But it's ridiculous. Why would anyone have a $1.2 million, especially the way the stock market's been going over the last few years, and not invest it in anything at all? It doesn't make any sense. And that the court has to consider that, not just ignore it and say, well, I don't trust this father. So the mother, she can go and spend whatever she wants. She could go and pretend that she doesn't make any money, and we're not even going to consider it. So the other change of circumstances is you have a child here from 5 years before was a lot younger. Now, she was 17 years old at the time of the trial. She turned 18 while this appeal has been going on. We don't know if she's emancipated. That's something that's going to have to be resolved at some point, but there's not evidence in the case about what her circumstances are.
Just to be clear, the judge's decision refers to the parties as emancipation is defined in the parties' agreement. We couldn't find the parties' agreement. I couldn't find the parties' agreement in the record. Can you confirm that the parties' agreement that the court refers to in its decision is not in the record?
I think you might be right, yes. It should be.
Thank you.
Well, actually, it should be in the docket. I mean, I hadn't thought about it, to be honest.
We'll look there. Thank you.
Right. Okay. Now.
So let's talk about the credit. You said in your brief, your reply brief, there was no dispute the father had been paying $659 per week until the reduction by the May 2023 order. Can you tell me why you wrote that? What's the basis for stating that? Because it was the testimony of both parties. Where is that? Where do I find that in the testimony?
I believe the father testified to it, and I believe there's also Department of Revenue records.
Well, let's look at that. So in Appendix 2, Volume 135, there's a list of all his payments.
Right.
And I'd like you to show me where there's even one payment of $659.
Did he make it by month or rather than weekly? I'm not
Well,
sure.
so I see two payments of $2,636, but that's not going to give me 20 weeks of $659.
I believe those were payments that were, there may be some additional payments, because one of the things he had to do was also pay some.
Okay, where will I find that in the record?
I believe that's all in the Department of Record.
Tell me where, because I didn't see it. You're telling me it's in the record. You're telling me there's testimony. Would you just tell me where it is, because I don't see it?
All right. I can't at the second point you to that, but I believe it's in the exhibits. I think it was all in the exhibits that established what his payments were. And I believe he also testified to it, and the mother acknowledged it, I believe, as well. But the court ordered, the reduction was only ordered at the temporary order hearing in May of 2000.
Right, but if he wasn't paying $659 a week in 2023 until that order, then he doesn't deserve credit for 659 minus 200 and whatever it was.
375.
Right.
Yeah.
He doesn't
Right.
deserve credit for that because he wasn't making those payments. So what do I do if I can't find that he made those payments with the credits?
Well, with that credit that I've argued from June till May, I believe all his payments. I think all his payments were there, and the record establishes that, and there was no dispute
Well,
about it.
why don't you just open the appendix now, Volume 2, page 145.
I don't know if I have that in front of me, actually. I don't
You
have
didn't
that.
bring your appendix to oral argument?
No. Sorry. I didn't.
right.
No, I didn't. I don't have it with me.
Okay, well,
I understand. I apologize, Your Honor, for that problem. But in any event, the point that the mother has tried to make about the $17,000 that was given as credit, that is a payment from Social Security to her and deposited in her bank account, and he's entitled to that credit. And to the extent that he's paid the child support from January to June of 2023, that no one disputed in the trial at all, under any circumstances, and I don't think it's disputed in this brief by the other side, he's entitled to have that credit as well. So I would just,
Let me see if there's any more questions from the
Sure.
panel. Okay. Seeing none, thank you very much, Attorney Draft.
thank you.
And we will now hear from the appellee. Ms. Smith, your 15 minutes starts right now.
Okay, may it please the court, I have 3 points to make in response to the brief. What I have to say should take really no longer than 2 minutes. Number 1, the trial judge denied Danforth's application to modify because he failed to show a change in his conditions. Absent evidence of changed circumstances, the trial court correctly refused to take further action on Danforth's application for modification. Each case cited by Danforth contains evidence of change of financial conditions, but Danforth had no credible evidence in trial, and his attempt to introduce this evidence on appeal is not appropriate. Number 2, the credit provided to Danforth in the order was a mistake. In fact, as the math reveals, Danforth's total payments up to that time, combined with the Social Security payments, actually caused an underpayment of approximately $400. Although he argued he was due a credit, Danforth did not offer opposing evidence. I received child support from Danforth and Social Security. However, the amount Danforth actually did pay was already reduced to the account for the Social Security payments. I introduced evidence at trial of the total payments I received from Danforth plus the Social Security benefits to demonstrate that the total amount of those payments, dollar for dollar, was approximately $400 less than the total amount that was due. Danforth's argument, there were no overpayments. Danforth's argument is wrong. There were no overpayments, and his rebuttal argument on this topic makes no sense because the total payments from Danforth plus Social Security benefits equal almost the exact total amount required. Danforth was not due some phantom credit, much less $21,000. Number 3, Danforth has failed to comply with his child support obligations since 2008. He has been denied modification despite litigation in 2011, 2013, 2016, 2017, 2019, 2020, 2022, and 2023, resulting in the 2024 judgment made the basis of this appeal. Danforth has made no payments since the order in 2024. That's all. Thank you.
Let me see if there's any questions from the, yes,
So-
Justice Ditkoff has a question.
So, ma'am, you said on the day of trial that the DOR was showing a $439 arrearage, but how do we know that arrearage counted the $17,000 as payment for child support?
So what I did is at trial, I gave the payments that were made through the DOR. I showed the checks that Mr. Danforth had given me directly, and I also showed the Social Security payments that were made into the account. So it was those three, two coming from Danforth through the DOR and private checks that he sent me, and then Social Security added in. What I did is I took it from the date of Palin's order to the date of the trial.
The date
Done by week.
from 2019, you're saying?
It was, Palin's order was 2017. So I took it, everything from 2017 to the time of trial, week by week. Yeah, that was evidence that was unopposed at trial.
Okay. Anything further? Justice Wood? No. Anything else you'd like to tell us?
No, that's it, Your Honor.
Okay, well, I'd like to thank both parties for their arguments. This case will be taken under advisement. The case is submitted. Thank you, and that concludes our session.
Thank you.